Mental Capacity Act 2005. A general guide on how the Mental Capacity Act affects you and how you can plan ahead for when you no longer have the mental capacity to make decisions for yourself. This overview is about the Mental Capacity Act. Its capacity, best interests, deprivation of liberty, health and welfare decisions, financial decisions, advanced decisions, lasting power of attorney, LPA, deputies, court of protection, and useful contacts. Note: this information applies to England and Wales. This information also applies to adults. It does not apply to children unless specifically stated. Deprivation of liberty. What is a deprivation of liberty? Your liberty can only be taken away from you in very specific situations. The Mental Capacity Act calls this a deprivation of liberty. It should only be used if it is the least restrictive way of keeping you safe or making sure you have the right medical treatment. Being deprived of liberty means that you are kept on a locked ward or in a locked room, where you are not free to go anywhere without permission or close supervision, and you are continuously supervised. This is against the law unless it is done under the rules set out in the Mental Capacity Act. This may happen if you need to go into a care home or hospital to get care or treatment, but you don't have the capacity to make decisions about this yourself. If you are living at home, you can also be deprived of your liberty lawfully if the Court of Protection makes an order allowing it. Deprivations of liberty are monitored by the Care Quality Commission, England, and the Healthcare Inspectorate, Wales. They write regular reports on the use of deprivations of liberty, but they would not be able to investigate individual cases on your behalf. Note: your liberty can only be taken away under the Mental Capacity Act if you are 16 or over. You lack capacity to agree to the restrictions. The care home or hospital where you are staying has successfully applied for an authorization from the local authority. The deprivation of liberty safeguard has been followed. Or where the Court of Protection grants permission. Example: John has memory problems that have gotten worse over time, and lives in a care home. Because of his condition, he is less aware of danger than a person without the condition. He is unable to cross a busy road on his own and does not understand that it is dangerous to cross a nearby railway line. John needs constant supervision and must be stopped from going out on his own. This usually involves keeping him in a locked room and physically stopping him if he tries to go out on his own. To keep him safe, this must be done on a regular basis. It would be unlawful for the staff to do this without using the deprivation of liberty safeguards, so they should apply to the local authority for permission, called a standard authorization, as soon as they realize it is necessary. Is a deprivation of liberty the same as being detained under the Mental Health Act? No, it is different from being detained under the Mental Health Act 1983. You do not need to have treatment for a mental health problem to be deprived of your liberty. You can be deprived of your liberty to keep you safe, or for treatment of other health problems. If you need to be detained mainly for treatment for a mental health problem, this will normally be done under the Mental Health Act 1983. If you are already detained under the Mental Health Act, the health professionals cannot at the same time apply the deprivation of liberty procedure under the Mental Capacity Act. What is the deprivation of liberty safeguards, DULS? The Mental Capacity Act says that your liberty can only be taken away by health professionals if they use the procedures called the deprivation of liberty safeguards, DULS, or if the Court of Protection has granted permission. This protects you from having your liberty taken away without good reason. However, a deprivation of liberty will not be used every time someone is admitted to a hospital or care home if they lack capacity to decide whether to be admitted. It should only be used if it is the least restrictive way of keeping you safe or making sure you have the right medical treatment. For example, you may need to be kept away from places or situations where your safety could be at risk, such as railway lines or busy roads. Or you may be given medical treatment in your best interests and without being able to consent to it. Note: key elements of the deprivation of liberty safeguards. It is in your best interest to take away your liberty. This means it is necessary to prevent harm to you, and the detention is proportionate, looking at how likely you are to suffer harm, and how serious the harm might be. It has become an unavoidable necessity to take away your liberty. Every effort should be made to prevent it from becoming a necessity. DULS can only be used to deprive you of your liberty at a care home or hospital. It cannot be used to take you from your home to a care home or hospital. This would need an order from the Court of Protection. How does the authorization process work? Before you can be lawfully deprived of your liberty, the care home or hospital where you are staying must get permission from the relevant authority, which would be a local authority, or if you are in hospital in Wales, it can also be a local health board or the National Assembly. This is called applying for an authorization. Before the deprivation of liberty is authorized, you will have 6 assessments, which may take place at the same time. You cannot have your liberty taken away unless all the 6 assessments are met. Note: 6 assessments. 1. An age assessment, to make sure that you are aged 18 or over. 2. A mental health assessment to confirm that you have been diagnosed with a mental disorder within the meaning of the Mental Health Act. 3. A mental capacity assessment to see whether you have capacity to decide where your accommodation should be. If you have, you should not be deprived of your liberty and the authorization procedure should not go ahead. 4. A best interests assessment to see whether you are being, or are going to be, deprived of your liberty and whether it is in your best interests. This should take account of your values and any views you have expressed in the past, and the views of your friends, family, informal cares, and any professionals involved in your care. 5. An eligibility assessment to confirm that you are not detained under the Mental Health Act 1983 or subject to a requirement that would conflict with the deprivation of liberty safeguards. This includes being required to live somewhere else under Mental Health Act guardianship. 6. A no-refusals assessment to make sure that the deprivation of liberty does not conflict with any advanced decision you have made, or the decision of an attorney under a lasting power of attorney or a deputy appointed by the Court of Protection. Length of the authorization. This depends on your personal circumstances and how likely it is these circumstances might change, though the maximum time allowed is 12 months. The assessor will make a recommendation based on your best interests. Renewing the authorization. Your hospital or care home can request a new authorization to begin as soon as your existing authorization has run out. Urgent authorizations. These can be granted where the need for your deprivation of liberty is urgent. They can be granted for a maximum of 7 days, and it can be extended once for a further 7 days by the supervisory body. Is a deprivation of liberty authorization always granted? Your deprivation of liberty authorization will not be granted unless all the conditions in the 6 assessments are met. The authorization must also be in writing. Include the purpose of depriving you of liberty. State why the supervisory body considers that you meet the legal conditions for using a deprivation of liberty. Contain any conditions attached to the authorization, such as steps to maintain contact with your family or meet your cultural needs. The care home or hospital where you are must do what it can to make sure that you and your relevant person's representative understand the effect of the authorization. Your right to request a review. Your right to apply to the Court of Protection. If your deprivation of liberty authorization is not granted, the supervisory body must inform you, the hospital or care home that made the request, any independent mental capacity advocate involved, every interested person consulted by the best interests assessor. Your care plan may need changing to avoid a deprivation of liberty. Can I challenge the authorization in court? If you think you shouldn't have your liberty deprived, you can challenge it by asking for a review of the authorization, or appealing to the Court of Reviewing the authorization. The supervisory body must review the deprivation of liberty authorization if requested to do so by you, the hospital or care home where you are staying, or your relevant person's representative. You may have to go through the 6 assessments again if your circumstances have changed. The outcome may be that the deprivation of liberty authorization is ended, the conditions attached to it are changed, or you still meet the conditions for deprivation of liberty, for a different reason. The supervisory body may also carry out a review at other times. You can ask the local authority for an independent mental capacity advocate to help you with this if you need someone's help. Appealing to the Court of Protection. You or your relevant person's representative have a right to appeal to the Court of Protection against a decision of the supervisory body. Any other person can appeal to the court, but they will need the court's permission first. Legal aid is available for you or your relevant person's representative to have legal representation at the appeal. The court may tell the hospital or care home where you are being deprived of your liberty that the authorization, standard or urgent, is at an end, or it may tell the body that granted the authorization to change it or end it. Where can I get support? You can get support from an independent mental capacity advocate, and/or a relevant person's representative, RPR. Relevant person's representative. This is someone, such as a family member, who can stay connected with you, represent you, and support you in all matters connected with the deprivation of liberty authorization. You can choose who you want to be your relevant person's representative if you have the capacity to do so. If you do not have capacity to choose your relevant person's representative, they may be chosen by your attorney acting under a lasting power of attorney, a deputy appointed by the Court of Protection, or the best interests assessor, who will try to identify a suitable person. The identity of the relevant person's representative will be considered during your best interests assessment, as part of your 6 assessments. If you have nominated someone you think will be willing to act as your relevant person's representative, the best interests assessor must recommend them. The supervisory body can remove a person from acting as your relevant person's representative if it considers that they may not be staying connected with you, although it should contact the relevant person's representative to clarify the situation before removing them. What if I am in my own home or in supported living? The deprivation of liberty safeguards can only be used if you are in care homes and hospitals. If you are deprived of your liberty anywhere else, an application must be made to the Court of Protection. This should be made by the local authority or clinical commissioning group, CCG, that made the arrangements for your care. How does the application process work? The local authority or CCG applying for an authorization must provide the court with information about your care arrangements and the reason any restrictions are necessary. A capacity assessment showing that you lack capacity to make decisions about your care. A medical assessment with your diagnosis. Your wishes and feelings about your care. The views of anyone interested in your welfare, such as family members. The Court of Protection will usually appoint a litigation friend or representative to act for you. They can object to the arrangements for your care if they don't think they are in your best interests. The Court of Protection will authorize the deprivation of liberty if it is satisfied that you lack capacity to make the decision yourself. The arrangements for your care are in your best interests. The authorization will last for up to a year and will need to go back to court before it ends. It can be returned to court earlier if the arrangements become more restrictive. You regain capacity. Someone believes that the arrangements are no longer in your best interests. How can I challenge the authorization? You should be involved in the application as far as possible and able to give your views to the court. Once the authorization is made, you or your representative will need to apply to court if you want to change the order.